Welcome to Epstein Becker Green's webinar, Privacy and Wearables, the fourth and final installment of our Wearables Crash Course webinar series. We are pleased to have Epstein Becker Green's Patricia Wagner, a member of the firm in the healthcare and life sciences and litigation practices, presenting today's webinar. Before we begin today's presentation, please be informed that today's webinar is being recorded and that participant phone lines will be placed on mute throughout the program. You are also able to submit questions directly to the presenter following the webinar, and contact information will be displayed at the end of the presentation. In approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. At this time, I'd like to turn the webinar over to Trish.
Thanks, Sylvia. So we only have 15 minutes, so of course I want to get started right away. First of all, at a high level, I just want to talk, I know this has been a long series on wearables. Today we're going to talk about privacy. And as you know or you'll see, there is a little bit of overlap between privacy and security, but I'm going to try to focus more on the privacy aspect of wearable devices, which is really, you know, what data do you have access to, what are you doing with that data, and how are you telling consumers about that? So the first thing we want to think about is who enforces privacy considerations. And certainly the Federal Trade Commission, the FTC, is very active in this area. State attorneys general also will have the authority to enforce in the privacy area. The Department of Health and Human Services, of course, if you happen to come under the Health Insurance Portability and Accountability Act, or HIPAA, or the Privacy and Security Rules as we more commonly know them. And then there are a couple of other federal regulators that sometimes may be implicated depending on what you're doing with the data and how you're communicating with consumers. But let's talk first about the Federal Trade Commission and what how they regulate. Their authority, actually they enforce. The enforcement authority of the Federal Trade Commission comes under the Consumer Protection Act, or the FTC Act. And really, the focus is, in this instance, are consumers harmed? Have consumers been appropriately informed of the information that they need to know? And have they been harmed in any way if that information has been hidden from them? The FTC also has the authority to enforce the Child Online Privacy Protection Act. I highlighted here, it's actually critical that if you're going to collect information from children that you make sure that you understand the implications of the Child Online Privacy Protection Act. If you are ever bored and have some problems sleeping at night, you can go to the FTC's website. They have a whole website devoted to their privacy enforcement activities, not just their enforcement activities, but those in privacy. It's under Enforcing Privacy Promises, and I have the link here on the slide. It's good to read through some of those cases just to get a feel for what types of issues are concerning to the Federal Trade Commission and how companies have gotten themselves into trouble, usually inadvertently, through their privacy policy. Now, state attorney general are the next enforcement body that we think about. They, too, are consumer protection. They're worried about consumer protection. All states will have a Consumer Protection Act that the state attorney general can act under. In addition, there may be specific state privacy statutes that allow for enforcement. For example, California has an Online Privacy Protection Act. Sometimes states get the authority to enforce through their breach reporting statutes. As everybody knows, almost every state now has a reporting obligation for a breach of some type of personal information, and that varies from state to state. And often those breach reporting requirements include a notification to the state AG, and from there the state AG can investigate to determine whether there is another activity that needs to be looked at. Again, state AGs are, like the FTC, they're very focused on consumer protection. Now, if we think about other federal regulators, certainly at the top of the list is Department of Health and Human Services. Now, this won't always apply. It applies to entities that are covered under HIPAA, which would be healthcare providers, health plans, and healthcare clearinghouses, or vendors to those entities. If a wearable has a direct-to-consumer relationship, and the direct-to-consumer relationship is one that is where the wearable is not a healthcare provider, then HIPAA likely wouldn't apply. Often what happens is a wearable device will do or enter into an arrangement with a health plan or a provider and become a business associate of those entities. And at that point, then the wearable device becomes subject to HIPAA and all of the requirements of HIPAA. And then, so I don't forget, at the bottom we have other federal agencies that are involved in privacy. Certainly we can't forget the Federal Communications Commission, the FTC. Most notably, if anything the wearable is doing is communicating with the consumer via cell phone, either marketing through that or sending text messages, you'll want to understand the implications of the Telephone Consumer Protection Act. And of course, as we've seen, the FDA is getting very interested in privacy and security of medical devices. Now, I did a slide. I mentioned the Child Online Privacy Protection Act before. I want to do a slide on it. Again, I can't highlight the importance of this statute enough. If you are collecting information from children under the age of 13, you need to do so in compliance with this act. It basically is designed to make sure that organizations are not collecting information from children without their parents' knowledge. And so really it is just a matter of making sure you are collecting the information appropriately if you want to collect information from children. I know a lot of our clients avoid this by making sure that their wearables or their apps or their websites are only available to individuals over the age of 13 or in some cases over the age of 18, but it is something to always keep in the back of your mind and make sure you're aware of. Now, as I mentioned, if we go to the enforcement action slide, sometimes it is helpful to think about some of the enforcement actions and talk about them so we understand how the FTC views privacy violations and what the concerns of the FTC might be. And I picked a couple of these to go through. The first one is NoMe. NoMe was a mobile device tracking technology that provided analytics services to bricks and mortar retailers. And while you may not think that's applicable in the first instance to wearables, what is applicable is what happened. So NoMe was designed to help retailers understand the flow of customers in their store. It was not designed to track, what Trish Wagner is doing at point A, point B, and point C. Rather, it was really designed so that the stores could understand, people really stopped and looked at this display, they passed by that display, they didn't spend any time at all over in this section, just to get the flow of what consumers were doing in the store. Now, NoMe got into trouble because its website policy stated that they pledged always to allow consumers to opt out of NoMe's services on its website as well as at any retailer using NoMe's technology. And that was certainly true for the website. NoMe allowed consumers to opt out at the website, but of course at retailers they were not allowed to opt out. There was no opt-out option at all, which the FTC took issue with. The next enforcement action I want to talk about involves Payments MD. Payments MD was an application that was designed to help consumers gather all of their claims information from their health plans and get it into a single place. And one of the things that the application did was provide authorizations for individuals so that the app would have the authority to go to a payer and ask for the health information. The FTC did not like the way this was set up. the allegations say that although they could have seen the statements telling consumers that they were going to go to payers and get claims information, that it was difficult to see the statement that indicated that. In addition, the FTC alleged that the design simultaneously made it hard to read through the entire authorizations and easy to skip over all of them by a single checkbox, okay? Now, you know, whenever you read an FTC action, it's important to remember that the FTC as a plaintiff or as a prosecutor in the case is going to make the facts appear as, you know, in the worst light possible. But you can imagine also how Payments MD maybe was trying to figure out how they could get information to consumers in bite-sized pieces so that consumers might actually read the boxes rather than just move through them. Perhaps most importantly in the Payments MD press release was a statement by Jessica Rich, who noted, among other things, consumers' health information is as sensitive as it gets. And that statement really reflects the attitude of the FTC that they are actively looking and trying to protect health information that's being gathered by organizations that fall outside of HIPAA, so that organizations that are direct to consumers that aren't covered under HIPAA, the FTC is trying to make sure that they fill that gap and so that information is adequately protected. Now, I want to talk just quickly about a state enforcement action. I like this example. It actually turned into nothing, but it's an example of what a state AG might do. The California AG went after Delta for the Delta app. It said it failed to meet the requirements of the California Online Privacy Protection Act and the Unfair Competition Law because it failed to conspicuously post a privacy policy. And most interesting thing about this case is that the state AG was actually looking for $2,500 in damages for each time the app was downloaded, which, as you can imagine, could probably get up pretty high. Now, the case was dismissed actually because of federal preemption, because of an airline exemption, so it's not going to be applicable to that preemption is not going to be applicable to everybody. So it's interesting to think about what state AGs might use and what weapons they might have in their arsenal should they need to bring an enforcement action. The Office for Civil Rights in the Department of Health and Human Services has also been very active. Those wearable devices that are vendors to a provider or a health plan have probably seen an uptick in the significance of business associate agreements and the importance of those in the negotiations. You can go to the top link there for a listing of enforcement actions by the Office for Civil Rights. Again, the two I've listed here, I want to make sure everybody understands they're not penalties for a breach. They're penalties for violations of some sort of privacy requirement under the privacy rule. So with that enforcement, let's think about how we can avoid enforcement. Transparency is the key. Tell consumers what data you're collecting, how you're storing it, who might receive it, what you're going to do with it, and try to make that information as clear as possible. It's incredibly challenging to do so when we're dealing with small screens or small places to display the privacy notices, but that is really key. The other thing to do is to take advantage of some of the resources that are available. The FTC has guidance on mobile technology, best practices for mobile health apps. FTC, FDA, and OCR put out a decision tree to help wearable device manufacturers understand where they fall or don't fall within the regulation of the FDA, HIPAA, and the FTC. It's maybe a little high level and a little simplistic, but it's a nice starting point for organizations to look through as they're developing their wearable devices. State attorney generals also often have information. California, again, has a ton of information on privacy and what businesses can do to ensure the privacy requirements are being met. There are lots of newsletters out there that you can get to understand what's going on in the world of privacy. The FTC has always suggested that organizations or wearable devices, apps, websites should all do privacy by design. In other words, be thinking about privacy at the start of the development so that it can be baked into the overall concept and you don't have to go back later and backfill. And that's particularly important if you are thinking about a wearable device that currently will be direct to consumers, but later might have a utility to, for example, a health plan or a healthcare provider. Obviously, those folks are going to be most interested in how you're handling the privacy of the information that you're collecting.
Thank you, Trish. This concludes today's webinar, and in approximately 2 to 3 business days following the webinar, Epstein Becker Green will communicate the availability of the webinar recording and access to the PowerPoint materials. Thank you for attending and have a great day.